If you're trying to write your own will, you need to hear this. What could go wrong with a do-it-yourself will? Well, a lot of things. Imagine this. You're trying to save money. You do not have a lot of assets to leave to others. Your estate isn't complicated. So you go to a bookstore or online legal site, grab a standard will form, and fill it in yourself. This is exactly what Ann Aldrich of Keystone Heights, Florida did back in 2004. So she left her property to her sister Mary. And if Mary died before Ann did, everything should go to her brother James. Simple, right? Well, as it turned out, Mary died first, and Anne inherited Mary's estate instead of the other way around. This is where it got complicated. When Anne died a couple of years later, Anne's nieces, the children of another brother, not James, sued, saying that the clause in her will where Anne left everything to James should not include the inheritance from Mary. And after years of court battle, with one court agreeing that Anne's nieces should inherit, another determining James should inherit, the final determination was that Anne's nieces would inherit the assets left by Mary, which was likely not what Anne wanted, but it is what the court decided. So what went wrong? Well, as the court wrote, this unfortunate result stems not from this court's interpretation of Florida's probate law, but from the fact that Ms. Aldrich wrote her will using a commercially available form, an easy legal form, which did not adequately address her specific needs, apparently without obtaining any legal assistance. The court went on to say, while I appreciate that there are many individuals in this state who might have difficulty affording a lawyer, this case does remind me of the old adage, penny wise and pound foolish. Obviously, the cost of drafting a will through the use of a pre-printed form is likely substantially lower than the cost of hiring a knowledgeable lawyer. However, as illustrated by this case, the ultimate cost of utilizing such a form to draft one's will has the potential to far surpass the cost of hiring a lawyer at the outset. In a case such as this, which involved a substantial sum of money, the time, effort, and expense of extensive litigation undertaken in order to prove a testator's true intent after the testator's death can necessitate the expenditure of much more substantial amounts in attorney's fees than was avoided during the testator's life by the use of a pre-printed form. The record indicates that Ms. Aldrich's brother sought to admit testimony that shortly before her death, Ms. Aldrich in fact had even consulted with an attorney who was to draft a will for her, but that she died just days before she was to review the newly drafted will. Unfortunately, this testimony was declared inadmissible hearsay. Nevertheless, it appears that Ms. Aldrich may have finally realized she needed legal assistance, but unfortunately that realization came too late. It sounds incredible and yes, unfair, but if your will is not drafted properly, your assets could pass on to somebody not even named in the document. And the real shame here is that Ms. Aldrich, Anne, was presumably trying to save money when she used a standard form instead of consulting a lawyer. But because she didn't fill out the form correctly, didn't ask anyone to advise her, the court was unable to honor her wishes and her money went to people she did not intend to inherit her estate. Unbelievable. But it's true. Listen, you've worked your entire career to support yourself and the people that you care most about. Why risk it all with a do-it-yourself will? The best defense is to get educated about how to avoid the mess that poor Anne left behind. Follow us on your favorite social media platforms so you can learn how to better protect your family.